la Unión Europea. Por supuesto, primero de todo, quiero dar la bienvenida a Juan Miguel Márquez Fernández, el director del Observatorio Nacional de Tecnología y Sociedad, a Luz Rodríguez, buena amiga, Universidad de Castilla-La Mancha, que nos ha hecho posible que hagamos este acto en el Parlamento Europeo, y dar también la bienvenida y el agradecimiento a los profesores que han hecho posible este estudio. Los voy a mencionar: el profesor Senatori de Unimor, profesor difícil de pronunciar, es Grzebik de Varsovia, Oktan, bueno, de Fair Work, profesor Ratti de la Universidad de Luxemburgo y profesor García Muñoz de la Universidad de Glasgow. Así que, sin más, hago una breve introducción. Para los que estáis más familiarizados no necesitará explicación, pero para los que quieran seguir este evento sobre qué son los derechos digitales, ¿no? Y bueno, consideramos que podríamos definirlos como el conjunto de derechos y garantías que protegen a las personas en el entorno digital, asegurando que los principios fundamentales que rigen en la vida offline, como la privacidad, la libertad de expresión, la igualdad o el acceso a la información, entre otros, también se respeten en Internet y en el uso de las tecnologías. Es una máxima que siempre hemos trabajado también desde el Parlamento Europeo con las últimas leyes, la anterior legislatura, la DSA, la DMA, con esta máxima, ¿no? Y querría poner una imagen que creo que siempre ayuda, ¿no?, a contextualizar mejor cuando hablamos de estos temas, a lo mejor más etéreos, ¿no? Y habíamos pensado que podríamos imaginar que Internet y el mundo digital son como una gran ciudad en la que todos vivimos, en la que todos habitamos, que hay calles, que serían las redes, hay edificios y coches, que serían las plataformas, hay comercios, que son los servicios digitales, y hay espacios públicos donde interactuamos todos y todos. En una ciudad física, como todos sabemos, existen normas y derechos que nos protegen, como la seguridad, la privacidad en nuestras casas o la libertad de expresión, que rigen nuestra interacción y, sobre todo, protegen a los habitantes de esta ciudad, ¿no? Pues los derechos digitales consideramos que son estas leyes, las normas de esta ciudad, pero aplicadas al mundo online, ¿no? Garantizan que nadie entre en tu casa digital sin permiso, como serían nuestros datos, que podamos expresarnos libremente sin abusos, como sería la libertad de expresión, pero también que todos tengamos acceso a los servicios básicos sin discriminación o sin sesgos, como lo que lucharíamos en el mundo offline, que también se aplique en el mundo online, ¿no? Y en el marco de la Unión Europea, estos derechos cobran especial relevancia ante el impacto creciente de herramientas como la inteligencia artificial, el tratamiento masivo de datos o la influencia que tiene hoy en día las plataformas digitales. Algunos datos para poner encima de la mesa y hablar: en la Unión Europea, alrededor del 30% de trabajadores
tools in their daily work, such as chatbots or automated analytic systems. And international projections indicate a major transformation of employment. This is something that will be very cautious to what you mentioned, and it is estimated that AI could eliminate some 92 million jobs, but create some 170 million new ones in 2030. That's why digital rights seek not only to protect users from risk, such as excessive surveillance or disinformation, but also to ensure fair, secure, and transparent access to the digital world. We're not talking just defensive tools, but also to create more secure and more safer world. How are these rights guaranteed? With concrete action routes and policies that strengthen our rights in the digital space in all its applications, use of social networks, online shopping, conversations, and also in the workplace. In the EU in 2022, we adopted the European Declaration on Digital Rights and Principles for Digital Decade, which is the key of the European approach to digital transformation. And its objective was to ensure that Europe's digital transformation is compatible with the values of the Union, such as the fundamental rights recognized as well in the Charter of Fundamental Rights of the European Union. It aims as well to strengthen the human dimension of the digital transformation, protecting European democracies and the digital model with our humanistic approach, which is our own approach. And we have to see the three big blocks Europe, the United States, and China to see how we approach this from a human point of view, or keeping into the core the human rights. And also, it should ensure the fair internet access, data protection and privacy, online security, technological transparency, and fair and inclusive conditions in the digital environment. It establishes as well that the promotion and implementation of its content is a shared responsibility of the EU and the member states, and that reporting on progress is an important element of it. Because we know that technology sometimes progresses faster than laws. So we have to have this monitoring and to be able to adapt our laws to new technologies. This chart is not legally binding, but reflects common commitments and serves as a compass for member states in their efforts to achieve the targets set out in the 2030 Digital Decade Policy Programme. And as an example, several member states have been adapting as well their own charters, such as Spain, for example, in 2021 already adopted the Digital Bill of Rights through a participatory process that involved various actors from the field of digital rights and had the aim as well to establish a set of rights that protect citizens' interests and freedoms in the digital field, ensuring their privacy and security on the internet, as well as their right to net neutrality and adequate digital education. And in the last year, I think it is more important than ever due to the arrival to Donald Trump to the White House and how he and the oligarchs manipulate the algorithms and how platforms are creating this source of information, mainly for youngsters. In this context of European reflection and framework that the reports will be presented today, focus on the application of digital rights in the work and business environment in the EU, and on the concrete implementation of different measures in a number of selected member states such as Germany, Italy, Luxembourg, Poland, Spain, and Sweden, providing clear and concrete examples on how member states regulate the digital rights of the Union. So now I'll give the floor to Luz to introduce the main objectives and the context of this report. And thank you all for participating today in today's meeting and for your effort to be here. Thank you very much. Luz? Good morning, everyone. Good morning to those as well here in the room and to those listening to us online. First of all, I wanted to thank Laura Ballarín, because when we called her about the possibility of presenting this report in the EP, she was very enthusiastic about it. And after a while, she's been here with us. And thank you, Laura, because I know you're making a massive effort to be here with us. So due to your recent maternity, your job, because women have that dual function as well, job and home. So thank you for bringing us here. Thank you to the EP. Thanks to the authors of this report that will be presenting. Thanks to Red Point ES, Juan Miguel Marquez, Director of ONCE, is one of the elements of analysis of the Red Point ES. And thanks to the European Commission as well, because everything we've done in the last 2 years regarding digital rights has been funded by the European Commission. So thank you very much to all big team of experts bringing us here today. Apart from what Laura said, for lawyers, experts on rights law, the fundamental rights exerted in digital field, these are a obstacle to the use of the technologies by the companies. Technologies allow us to write our work in any time, in any moment, allows as well the capture of the personal data of workers. Technology also allows, through algorithms and AI tools, to manage decisions made previously by people in workers, and they do it now through these technological tools. And all this array of tools could create a wild spread of the possibilities of the decision by the companies. The role of the digital rights is to limit the power of the use of technologies. The right to disconnect allow us to limit the time of being available for a worker to the company. Data protection allows us to not take some data, and the new norms and the new regulations regulate rights of transparency of the use of algorithms in the digital technologies and tools, allow us to limit how to use these digital tools in the online world and how to use them in such a way that don't create any obstacles and risks. So for us, digital rights limit somehow and create limits to the managing powers. Regarding digital rights, the EU, as Laura was mentioning, has been at the forefront of many cases, and big companies coming from the United States and China are limited because EU now created something that is the digital constituency, and is a limit to the use of these digital tools. And due to the time I have, I will just say that the GDPR is created a space for digital data that we can see nowadays in Latin America as well, and other regions where the GDPR is mainly copied and pasted in other geographic regions of the world. So the European Charter for Digital Rights creates the human at the core, and is one of the example of this digital constituency, and the creation of platforms in a personal space make possible to have some rights on the use of algorithms to be spread to other companies and other societies. And I would like to highlight, because sometimes we forget about it, but I wanted to highlight here that we have the agreement on digitalization of the social partners that signed already in 2020. And that shows clearly the role of the social dialogue and the social partners in the governments of the use of digital tools in the digital world, and the social dialogue as well, and the collective bargaining. Spain has been one of the best students, so to say, in this case, because in 28 already created the law 2003/8, and created their own digital act in the digital field. And we can make a reference as well to this progress, our own Rider Act, such as we know it in Spain, for the regulation of contracts on digital platforms, and to be able to regulate as well the labor conditions on workers, and to be able to have the information on the transparency and the use of algorithms by the company. And this is a forefront act, and now it's been copied everywhere. But we also have the Digital Charter. And this is a charter that is not legally binding per se, but thanks to that as well, we want to create all these tools to make them more available, because all the tools that I mentioned before are not legally binding. So we wanted to include in our report the tools that are not legally binding, but that could be implemented somehow, and to access the member states in the EU, and to be able to govern the digital transition. And to sum up, this is what we've done so far in five countries that we thought they were important in the digital transformation. And we want to present here today are the outcomes of how some countries in the EU have interiorized these tools to be able to carry out the digital transformations. And as, again, those are tools that are not legally binding. That's all from my side, but I want to give the floor to Manuel Antonio Garcia, the coordinator of this report and the coordinator of the expert group. And Antonio, you have the floor. Thank you very much.
The online participants can follow me because they are going to speak right now. So without any further ado, I will give the floor to them and they will have 7 minutes to present the main conclusions of each of the national reports. And then I will make the general conclusions at the very end in Spanish again. So we will go in the following order. First, Jacopo Senatori, who coordinated the Italian team, will intervene. I will do the timekeeping and I will tell you when your time is finished, Jacopo.
Okay, well, thank you very much. I hope you can hear me. And good afternoon, everyone. I would like just to spend a few seconds of this time to thank sincerely Antonio and Luz for involving us in this important project and also for organizing this presentation. And I also wish to extend the credits for the work that I am presenting to my colleagues and co-authors Federica Palmirotta and Ilaria Purificato. We decided that I would be the only presenter given the time constraints, but this our chapter of the report was a common endeavor. So it's very complicated to summarize the findings of our report in just roughly 6 minutes now. So I will try just to make the main points, provide a few examples. So if the idea of the project was to check whether and to what extent the national systems are aligned with the principles set out in the documents that you have already mentioned, Antonio and Luz, the European Declaration on Digital Rights and the Social Partners Framework Agreement, the first answer as for Italy could be that at first glance, yes, at least in part, the system is aligned, although the process of alignment, of course, is still ongoing and incomplete. And the alignment could, to some extent, be unintentional. Why unintentional? Because, well, the regulatory initiatives undertaking at the EU level, of course, have influenced the most recent legislative output. We have a recent piece of legislation, a law decree passed 2 weeks ago, implementing some provisions of the platform work directive. So the influence is clear and it's also mandatory, as we know. But we may say that on the other hand, and this is a feature that I would like to stress of the Italian system, on other subjects, the Italian legislator has to some extent anticipated the EU initiatives, and the example could be the rules concerning transparency on the use of algorithmic management system that predates the regulatory interventions at the EU level, and also some well-established pieces of legislation dating back years or decades have proven to be enough flexible or adaptable to be used also to address the challenges posed by digitalization. Another question of the report was to what extent the industrial relations systems, the social partners, were, keeping up with the challenges of digitalization. In this case, it's harder to make an assessment, but the impression is that the action is slow and fragmented on this side. And furthermore, there is no clear indication of any role played by the social partners agreement at the European level to inspire and shaping the initiatives taken by the Italian social partners. So I have time only to make a couple of examples, and I think that it's a good example of this adaptability of the Italian system of rules to the challenges of digitalization is health and safety. The Civil Code includes a pivotal provision, Article 2087, which states that the employer has an obligation to adopt all the measures necessary to protect workers according to the specific features of the work activity, the experience, and the technical knowledge available. And I think that the interactions with the technological risks, in this case, from the perspective of these provisions, are biunevocal. Because on the other hand, the provision implies an obligation to assess the risks entailed in the adoption of the new technologies and to review and adapt the work organization accordingly. But on the other hand, it says that the new technological products that could enhance risk prevention, like in artificial intelligence, for instance, should be introduced when necessary in order to provide the most effective protections for workers' health and safety. And of course, this is the basic normative ground on which we can observe an influence of EU law, specifically related to digitalization. And again, I can make only an example that I draw from the so-called Italian AI Act, a piece of legislation enacted in 2025 in coordination with the European AI Act. At the Article 11, this provision states that artificial intelligence must be employed to improve working conditions and to protect the psychological and physical integrity of workers. And although this is mostly a programmatic principle, it's noteworthy to stress that it is consistent with the European Declaration and the Social Partners' agreement. And of course, there would be much more to say, but I have only 1 minute left. So I will say a few words about the role. Oh, sorry, I anticipated the stop so that it could be prepared. So I was going to mention the role of trade union initiatives, and an important one concerns disconnection, which in our view represents a flaw of the system. The regulation of disconnection is problematic to some extent because, first of all, it does not have a generalized character, but it applies only to remote work. Second point, the legal regulation on this matter is very scarce, and this is a matter regulated mostly by collective agreements. And there is an example. In December 2021, social partners signed a protocol on agile work in the private sector, recommending that collective agreements adopt specific technical and organizational measures to guarantee these connections. So, from a methodological perspective, this initiative can be seen probably as an indicator of proactivity of the social partners and of a healthy social dialogue, considering that the agreement was promoted by the Ministry of Labor. But on the other hand, the substance of the contents of this tripartite agreement are weak because they do not provide precise indications on the way in which the effectiveness of the right to disconnect can be guaranteed. And as I said, there is a lot more to say and to be read in the report, but I've tried to summarize lights, shadows of the alignment of the Italian system to the European framework. And I think that my time is already up. So, Antonio, if you confirm, I can stop here.
Yes.
Okay.
Thank you, Jacopo, for your very clear intervention and the perfect time management. So I will now give the floor to Piotr from the University of Warsaw.
Hello, can you hear me? Yes, okay. So thank you, Antonio. Thank you, Maria Luz, for having me in this very interesting project. And since I have only 7 minutes, I will focus mainly on the main findings of the Polish National Report, and will build the presentation around one central argument, which is Poland has digital transformation policy, but does not yet have a coherent digital labor rights strategy or legal infrastructure. Yeah, what I mean is that Poland is not a country where nothing is happening in the field of digitalization. There are a lot of digital strategies, AI policy documents, programs on digital skills, and a new labor code reform on remote work. But these are instruments, policies, documents, do not create a coherent framework for the protection of workers' digital rights. So my point is that the Polish model is strategically developed, but normatively very, very weak. So at this point, I need to just name the most important national digital policy documents. The first one is the Road to the Digital Decade until 2030. It's the main national framework coordinating Polish transition, digital transformation, and it's aligning with the European Union Digital Decade objectives. So this is the most important policy document. The second one is the Digitalization Strategy to 2033. This document uses the language of fair digital transformation and recognize some of its social aspects, including platform work or the situation of people affected by technological change. And the last policy document at the national level I'd like to mention is the AI Policy 2020, which speaks about trustworthy and human-centered AI, innovation, digital education, reskilling, and upskilling. So the language of Polish digital strategies, policies, is mainly the language of infrastructure, skills, innovation, e-administration. It's not the language of enforceable labor rights. So at this background, the most interesting development is happening in classic labor law. The example number one is the draft amendment of Article 28 of Trade Union Act of 2024, still pending, not in force. So the proposal would extend trade unions' right to information, so-called right to know. So according to this amendment, workplace trade union organization would have the right to request information about parameters, principles, and instructions on which algorithms or AI systems are based, if only this algorithm or AI system influence decisions affecting working condition, pay, access to employment, continuation of employment, including profiling. So this proposal is important because it treats algorithmic management as a collective labor law issue, not only as a data protection case. Of course, this proposal, it was highly inspired by the Spanish case, but it is limited. It does not create a detailed consultation procedure, does not create mechanism for expert review, or does not solve the very important practical question of the balance between trade secrets and the access to the information. So this draft of 2024 is symbolically important, but institutionally very weak, still not in force, and it's pending already for 3 years in the parliament. The next important issue is the right to disconnect. There is no separate legal definition of such a right in Polish legal system. What is interesting that the Polish government clearly has stated that the existing working time rules are sufficient to protect workers' rights and interests. Here I would like to mention the initiative of the Polish trade union Solidarność that ran the project on digitalization of the labor market, and they developed copy-paste model clauses on the right to disconnect that can be implemented to the collective bargaining. But these are interesting examples of good practices only and remain project-based and experimental. The third area I would like to mention within the time limit is the remote work that was implemented in our legal system in 2023. So, and I would like to mention the OSH element. So in a Polish legal system, the employer remains responsible for the safe and healthy working condition, but his responsibility is modified because it's based on shared responsibility. So the employer is preparing the risk assessment, provides information, defines working rules that need to be accepted by the employer. What is interesting in Polish case is this risk assessment covers also psychosocial risk that includes social isolation, alienation, and the mental health affected by the working apart from colleagues. So the last thing I would like to mention within 1 minute left is the activities of the trade unions. Both Polish, the biggest trade unions, Solidarność and OPZZ, were involved in European Union-funded projects. One of them is digitalization of the labor market project coordinated by Solidarność that focus on the right to disconnect, and the other is TUDO project, which focus on the building a network of trade union digitalization officers. So now my main conclusion of the Polish National Report is that we did not create a coherent model of worker protection, trade union participation, algorithmic transparency, and democratic governance of the technology of work. Government is interested in producing a lot of policy document without any enforceable rights. Thank you very much.
Thank you, Piotr. That was perfect on time and very, very clear. Thank you very much. And now I will give the floor to one of the co-authors of the German report. Didem, the floor is yours.
Thank you very much. Hello, I'm Didem Özgür Sultan Wagenführer, and together with my colleagues, Patrick Feuerstein and Tobias Kuttler, we have written this part of the report, Germany part of the report. And I should say, while writing was not easy, because in Germany there are lots of rules, regulations, and initiatives on this issue. And we had to choose what to put into the report, because report has also a word limit. So what I'm going to present here is only the most important or most conspicuous aspect of this area. So when we look at the implementation in the field of occupational health and safety rights, what we see is there is European OSHA initiative, Safe and Healthy Work in the Digital Age. And this aims to raise the awareness and promote good practices to improve workplace safety and health in the digital age. We also see, for example, adaptation and improvement of the German joint occupational health and safety strategy in a way to address the challenges of digitalization. We also have research-focused program put into place by the German Federal Institute for Occupational Safety and Health to develop and update technical and organizational OSH requirements to inform policy and practices in the area of OSH. And also we see the involvement of the Commission for Occupational Health and Safety in standard setting at the workplaces undergoing the digitalization process. When we look into the roles and activities of trade unions, there's various examples. To say a few, we see, for example, trade union initiatives on skills development and collective bargaining in the digital age. So various trade unions equip their members and representatives with skills for digital challenges. We see courses, we see workshops, various different activities. There is also funding programs of the federal government, the digital qualification of works councils and trade unions. It aims the digital qualification. So the federal government promotes the co-determination and helps the works councils and trade unions to navigate the legal, technical, and AI-related challenges in digitalized workplaces. When we come to the right to disconnect, Germany has the German Working Time Act, and this act prevents the employers from requiring constant employee availability. This is a framework act it doesn't have strict limits. So what does give to the workers is a room for negotiation. So the employers cannot require from their workers constant availability. Therefore, the works councils, the workers as individuals as well, or the trade unions can negotiate how to use this right. When we look into the safeguarding of workers' fundamental rights, what we see is the Works Constitution Act requires works councils' consent for monitoring devices, for introduction of the monitoring devices. But when there is no works councils, then in the workplace, then this is the problem. Then there is a room for maneuver for the employers. There's also the Federal Data Protection Act, imposing strict limits on the processing of employee data, and it protects against automated decisions. So especially this Data Protection Act is really strict. So employers have a lot of limitations in using the data collected from the workers. However, as a Fair Work project, we are looking into platforms, for example. We see various problems in implementation of this right as well. When we look into the use of AI in the working environment, what we see is the Works Constitution Act grants works councils co-determination and consultation rights on AI and monitoring tools. However, this is, as I said, this is co-determination, but still, if there is no works councils, this is problem. This is a problem. There is also a artificial intelligence strategy of the German federal government. This strategy promotes a human-centered approach to AI in the workplace, balancing worker and employer interests. However, this is a strategy, so it has to be turned into policy and practices, and it is being done step by step. Hasn't been realized 100% yet. Finally, the key practices, when we look at the key practices, key best practices, we see various key best practices on different levels, like on federal level, on workplace level. What we can give as an example is the federal strategy. There is a Work 4.0 federal strategy aiming to shape the digitalization in a socialist responsible way. So what does it do? It funds the programs to support works councils and unions in developing digital competencies, also to understand the data protection, what is worker surveillance, to understand all these issues in the age of digitalization. There are training programs funded by this strategy. Finally, there is two widely cited company level examples. One is Volkswagen from since 2012. At Volkswagen, there is a company level agreement prohibiting employees from accessing their work-related digital tools beyond the regular working hours. So beyond the regular working hours, they cannot reply their emails if it is about work. And we also have another example, IBM Germany. There's an AI framework agreement at IBM Germany, ensuring that AI doesn't compromise human decision making, data privacy, or employee well-being. And this is all from the German team. Thank you very much, and I give the microphone back to my colleague.
Again, perfect timing and very clear intervention. Thank you very much, Didem. And last, from the national experts, we have Luca Ratti from Luxembourg. Luca, the floor is yours.
Thank you so much. Thanks, Antonio. Thanks so much, Marie-Ruth. I had prepared a few slides, but it's just to ease my job in keeping the time. And I wanted to point out to your attention a little bit the context in which the Luxembourg system has developed, particularly in this field with digital rights, because Luxembourg is still a country very much based on social dialogue, where traditional trade unions play a role, and where the channel vis-a-vis the government and politics more in general is always open, which means that Luxembourg can be seen as an example of a place where some experiments have been done, some anticipations have been done of even of EU law. So the main focus is a few initiatives that have been put in place by different actors in Luxembourg so far. Some of them, as Piotr and other colleagues have mentioned, is more policy documents. So it's more kind of a roadmap of the government or some institutions of Luxembourg implementing digital rights. But some other initiatives instead are much more important. On this, I would like to mention two in particular, because this is hard law. And the two ones are, on the one hand, the amendment of the labor code on telework, and on the other hand, the amendment on the right to disconnect. Now, the amendment on telework is a cascade effect on the social dialogue, the agreement on telework. And the particular aspect of this amendment is that now telework represents one of the items that are part of the information and consultation dialogue between any employer and the staff delegation whenever the company wants to introduce, change, or transform their telework regime. And this, why is this important? Because it channels through information consultation rights any change, any organizational change which includes telework. And the second initiative is on the right to disconnect. Of course, in Luxembourg, we were well aware of the German debate and on the French debate on this. You must know that oftentimes Luxembourgish legislation is based on comparative examples. Well, on the right to disconnect, Luxembourg anticipated some other jurisdictions in the sense that they introduced a significant amendment in the Code du Travail. And in particular, they did two things. On the one hand, they recognized the right to disconnect as such, meaning that the individual workers do have the right to disconnect, which goes beyond what Didem was just mentioning. So working time legislation and the division between working time and rest time. But at the same time, they delegated the specificities, so the specific regulation of the single right to disconnect to collective bargainings concluded at enterprise level. Not only this is important, but this is associated with specific sanctions on the shoulders of the employer. So this system nowadays, to me, represents a very nice way to combine collective autonomy of social partners, so their freedom to negotiate on the right to disconnect, but at the same time to put a placeholder in terms of individual rights. What I just want to conclude on this, not only parliament and governments are important actors in the implementation of digital rights at workplace in Luxembourg, but also other actors. In particular, the last line of this slide is on the CNPD, which is the National Commission for the Protection of Personal Data. And when they issue opinions, there is already a blueprint on what can happen in the future. So a suggestion, it is a very concrete suggestion to the legislator what can be done in the future. And recently, in May 2025, they issued this opinion on the implementation of the AI Act, which is now a blueprint that the government is going to follow. Really, to conclude on Luxembourg, I think that's by far the best practice that has been put in place on digital rights is the right to disconnect, because of the flexibility of the solutions adopted by the government. Secondly, the government just tabled a little bit ahead of time, proposed implementation of the Platform Work Directive, which contrary to the tradition of Luxembourg of doing minimal implementation, so copy-paste of directives in the field of social policy, in this particular case, they went well beyond what the directive does, particularly with Chapter 2 of the directive on the status. So they implement the presumption of subordination in a way which goes well beyond what the directive minimally prescribes. Last but not least, on tripartism, this is a country based on tripartite dialogue. Still, nowadays, this tripartite dialogue at times is endangered. So trade unions are, the pendulum of tripartite dialogue with the government is now swinging on the wrong side. So we all hope that social partners will be back on track with the government. Thank you so much.
Thank you, Luca. Thank you. So thank you all. It was very clear interventions and on time, but because we started a little bit late, we are already late. So I will try to make my intervention as short as possible. La voy a hacer en español.
I'm going to speak in Spanish. I'm the coordinator of the report. I'm the one who is supposed to present conclusions about the report. So I'm going to focus in 3 specific trends that we have seen. First of all, the influence of the European Declaration and other European initiatives of the European Union in all the strategies that we have seen. Secondly, the existing European framework has an impact because different strategies are diverse. We see different solutions and different strategies at national level, even if we do have a framework. And then the third thing is to take into account the importance of institutions when talking about digital rights, artificial intelligence, and so on. So as Piotr said, the declaration has a clear impact on different initiatives adopted at national level. We can see different examples in national reports. For instance, the European campaign of OSH in digital environments. This has a huge impact in Germany, in Poland, and also in other places, Spain, Poland, Germany, Italy. We can see the artificial intelligence strategy, which had an impact in the national strategies, or in the Polish case, we saw that some initiatives are funded by the European Union, and this one served to foster the participation of social agents. But having said so, strategies are different in member states. And we can see that these differences are linked to the institutions and the legal framework which existed before at national level. For instance, the right to disconnect. We have some countries, Poland, Sweden, Germany, they think there is nothing else to do because they already had something regulated before. But there are some other countries which have decided to do something else and to draft new law, for instance, Italy, Spain, or Luxembourg. Or there are other countries who are used to co-management. Luxembourg, Germany, Sweden. There's also an important role depending on the role of collective bargaining. Spain, Italy, as Luca said. But in Poland, for instance, due to its collective bargaining structure, as it is different than the other countries, trade unions do participate differently. They do not participate that much in social dialogue, but they are directly linked to some specific initiatives which are funded by the European Union. The importance of the institutional framework. We have seen that institutions are essential in order to implement national strategies linked to digital rights. And these institutions did exist previously. For instance, the OSH Institute in Germany, it had a key role, but in Spain we have another one also. The OSH Institute is very important. In Luxembourg, we have just seen some examples. The CNSF, the last one in the slide, is also very important in order to implement strategies. And we can see this even clearer when we talk about data protection. Normally, countries do delegate in agencies which already work on that topic, nationally speaking, and something similar happens to fundamental rights protection. Normally, countries which appear in the report, they do trust what they already had before, and now they just extend it to the digital rights. And to conclude, I would like to say that the artificial intelligence strategy adopted in different countries is very important because it is the least implemented of the charter. So there are some national strategies and they are getting inspiration from the European strategy, but they're not really thinking about working or label things. They are talking more about technologies and more technological things. They're not really thinking on workers' rights. So maybe Italy is the one who has advanced more because they do have an observatory. In Spain, we do have some things as well, but in the rest of the countries, things are still in a first stage. The report has many more things which are very interesting to read, but we do not have more time, so these are the main highlights. Thank you very much to all the authors for their participation and their inputs. Thank you.
Muchísimas. Thank you very much to all the authors again. The reports are excellent in every one of the countries. The conclusion report is really fantastic. And as a researcher myself that tried to analyze this digital field, it is a pleasure for me. It is an honor for me to be here with you and to be able to read your work. Thank you very much. And we're running out of time, but we have also a representative of REDD.ES, Juan Miguel, who is the ONCE director of the observatory regarding the digital services in our country. I think he's here with us today online. Juan Miguel, you have the floor now.
Muchas gracias. Gracias. Sí.
Thank you
Gracias.
very much.
Permítanme presentarme primero y presentar
I would
también un
like
poco
to
la
introduce
institución a la
myself
que
first
represento.
and to introduce as well
En primer
the
lugar,
institution I represent. First of all,
en primer lugar, decirles que en España, bueno, soy Juan
in
Miguel Márquez, director
Spain,
del observatorio, como ha dicho
I am the
Mariluz.
director of the observatory, as
El
Mariluz
observatorio está
mentioned.
dentro de una entidad que se
The
llama Red.es,
observatory
es una
is
entidad
within
pública y
a
depende
institution,
del Ministerio para la
Red.es,
Transformación
depending
Digital y de
on
la,
the
y de la,
Ministry for
y de la
Digital
Función Pública.
Transformation and Public Services.
Hace años pusimos en marcha en España un programa para
Few
impulsar la
years ago,
implementación de los derechos digitales.
we introduced a plan for the digital services.
Para ello firmamos convenios
And
con
for that, we signed
unas
different
40
agreements
instituciones,
with
universidades,
different
centros de
40
investigación, organizaciones sin ánimo
institutions,
de lucro,
universities, academia,
sindicatos, organizaciones empresariales,
trade unions,
para
companies,
recoger la opinión que tenían
to
ellos
gather
sobre
all
el
the
desarrollo de
opinion
los
that they
derechos
had
digitales y sobre
regarding
qué
the
se
development
tendría que
of
hacer.
digital services and what should be done.
Hoy el trabajo que se ha presentado aquí es
Today,
uno de
today's
los
work
productos
presented
de
here
esta
is one of the
colaboración.
outcomes of this
Y quiero
collaboration.
agradecer
And
a
I wanted
todos
to thank
que habéis
everyone
participado en el mismo, el trabajo
and
realizado,
to all
que para
the
nosotros es
participants in this
de
work,
máximo interés
because for
el
us it was of
conocer
the utmost interest
cuál es el estado
to
del
be able
arte
to
de los
know
derechos
the
digitales en el ámbito digital, en el ámbito
state
laboral,
of play of this
en
situation at
algunos países de la
workplace
Unión Europea.
in some countries in the EU.
Creo que este estudio llega en un momento
I believe that
especialmente
this
relevante.
study comes in a very relevant
Estamos
moment.
asistiendo a una transformación
We
profunda
are
del trabajo
witnessing a deep
impulsada por la
revolution of
digitalización,
work
la
fomented
inteligencia
by
artificial y las
the
plataformas digitales.
digitalization, AI, and digital platforms.
Esta transformación está redefiniendo no
This
solo
transformation
cómo
is
trabajamos,
shaping how
sino
we
también
work,
qué significa
but
trabajar,
also
cuáles
what
son
does
nuestros
work mean?
derechos y cómo se
What
protegen.
are our rights and how we can protect them?
Por eso, estudios como el que hoy
That's
se han
why
presentado son
the
esenciales.
study presented
Eh,
today are fundamental.
La cuestión, creo, no es si la
The
tecnología
key
transformará el
question, in
trabajo.
my opinion, is not to
Eso
ask
ya está
ourselves if
ocurriendo,
technology will reshape our
sino
work.
cómo
That
queremos
is
que
already
se haga.
happening. But the real question is, how do we want it to happen?
Con demasiada frecuencia, el debate sobre
Very
tecnología y
often
empleo
in
se plantea en
debates on
términos de
technology
amenaza,
and work,
automatización frente a
there
empleo,
is statements
algoritmos
of
frente a derechos o
threats
eficiencia frente a
and
bienestar. Pero la tecnología
other issues,
también
but
encierra un enorme
technology
potencial para
also
mejorar
include other
la vida
potential
de los
to
trabajadores.
improve the life of
Creo que
workers.
tenemos que ser
I believe
ambiciosos
then that we have to be more ambitious
y aspirar a que ese sea el
and
resultado final.
to
Creemos que puede
make
contribuir a
that our
eliminar tareas
final
peligrosas y
outcome
repetitivas,
that could
facilitar una mayor
help us to
conciliación,
avoid repetitive
abrir
tasks
oportunidades de acceso al
and
empleo
open up new
para colectivos
employment
tradicionalmente
opportunities
excluidos. Puede
and
mejorar
new
la
forms.
formación
I'm
continua
really
y la
sorry,
adaptación a lo
Juan.
largo de la
I'm
vida
really
laboral.
sorry, Juan Miguel. Excuse me, Juan
Sí.
Miguel. I don't know if you can
Yeah.
hear me now. I'm really sorry, but we have to close this meeting in 2 seconds because this room is taken and they
Okay.
want to take over the
Okay.
room. I'm really sorry.
this case,
We have
okay.
30 seconds.
Ok. Pues entonces,
Then
acabo mi intervención solamente
I'll finish my
animándoos a
intervention
que sigáis trabajando en este ámbito.
calling you to
Creo
keep
que
working
habéis
on
hecho una
this
descripción
issue
magnífica de cuál
and
es la situación
thanking you for
actual,
the
cómo nos
real
encontramos
description of the
y
situation,
que vuestro trabajo
our
ofrece
situation,
muchas
and saying that
evidencias,
your job
plantea preguntas y nos
creates
ayuda
many
a orientar
evidences,
mejor
pose many
nuestras
questions,
respuestas.
and
Pero
help us
permítanme
to
terminar con una
guide
reflexión
our
solamente.
work.
Que el
And my
futuro del
final
trabajo
reflection
no
is
está
that
escrito en el
the
código de
future
los
of work
algoritmos,
is not
está en
written
nuestras
on the
decisiones
algorithms'
colectivas.
codes, but
Y si
on our
acertamos en estas
collective
decisiones,
decisions. And
la
if we accept
tecnología no
those
será una
collective
amenaza para
decisions,
los derechos
technology
laborales,
will not
sino
be a
una
threat
herramienta
for
poderosa
the
para
labor
reforzarlos.
and
Muchas
work
gracias
rights, but a tool to
y
reinforce them. Thank
muchas
you very
gracias por su
much.
trabajo y por su
Thank you very much
compromiso y
for
por su
your work,
atención.
your
Gracias.
commitment, and your attention. Thank you very much, Juan Miguel. Thank you very much, everyone. Goodbye and good afternoon.
Ciao.
Bye.
Goodbye.
Thank you.
Goodbye,
Bye-bye.
everyone. Thank you so much.
Goodbye. Thank you.